So today I wanted to talk about California's enrolled bill rule, the EBR, and actually propose a different approach for California's EBR. And I addressed the question whether the enrolled bill rule should serve as an absolute bar to legal challenges to enacted statutes in this state. Now, before I address the question, I should probably explain what the enrolled bill rule is. The EBR is based upon our separation of powers doctrine. Now, in general, the judicial branch of government is loath to review the record-keeping practices of the legislative branch of government in determining whether statutes were properly enacted or not. And this limitation on judicial inquiry is known as the enrolled bill rule, the EBR. And actually, the EBR dates back to the 19th century. And basically, this legal doctrine holds that if an act of the legislature is properly enrolled, authenticated, and filed, then it's presumed by the judicial branch of government that all of the steps that were required for that law's passage were properly taken by the legislative branch. And in the California courts, they've said even the journals, the daily Senate and Assembly daily journals of the legislature, are not available to impeach that fact. And now, what is a minority of the states, but it includes California, this presumption is a conclusive presumption. So based upon the California Constitution's enumerated separation of powers doctrine that is set forth in Article 3, Section 3 of our state constitution, again, the reasoning behind this limitation is that the judicial branch doesn't want to infringe on the constitutionally enumerated power of the legislative branch of government because it governs its internal affairs. And of course, it has the constitutional role of lawmaking. Now, the enrolled bill rule is utilized by the judiciary to limit its inquiry into whether a statute was properly enacted or not. And again, basically the EBR means that the courts presume that the required procedural rules for the proper enactment of a statute that they've been complied with the legislative branch of government. And again, specifically, this EBR doctrine precludes judicial review of the enrolled bill in a legal claim that any procedural requirements were allegedly not properly followed. Now, from my perspective, and it is a majority of the states, the EBR should not preclude all judicial review of an enacted bill. Now, while the judicial branch certainly has traditionally upheld its role as the final arbiter of what a statute means or how a statute should be interpreted, the judicial branch of the federal and state governments have traditionally deferred to the legislative branch of government in determining whether a bill has been properly enacted into a statute. But in my mind, an absolute deference should not be the standard used in California going forward. Legislative enactment should, in fact, be subject to judicial review rather than be immune from judicial review. Now, a number of courts in other states over the years have, in fact, questioned whether the enrolled bill rule should be rigidly applied. For example, the Supreme Court of Kentucky, in a case called D&W Auto Supply versus the Department of Revenue, ruled that the presumption in their state could be overcome in certain instances. Here's what their Supreme Court said. We believe that a more reasonable rule is the one Professor Sutherland describes as the extrinsic evidence rule, found in 1 Sutherland at section 15.06. They said other jurisdictions have embraced this, which we hereby adopt as the law of this case and future cases. Under this approach, there's a prima facie presumption that an enrolled bill is valid, but such presumption may be overcome by clear, satisfactory, and convincing evidence establishing that constitutional requirements have not been met. Turning back to California, almost 100 years ago, the California Supreme Court ruled in a case called Taylor versus Legislature that a statute that's been properly enrolled and authenticated conclusively establishes not only the contents of the law, but the due performance of all the steps required for its passage by the legislature. They said this is the general law and has long been the rule of decision in the state. And as recently as 2009, in the California appellate court case, the courts in this state have concluded that the enrolled bill rule is still in full effect in California. I looked back at one of the most famous cases dealing with this in California in 1927. And the California Supreme Court described the EBR as having long been the rule of decision in the state. This was the case of Sherman versus Story. Now, in Sherman, it was an 1866 decision. The court refused to consider uncontradicted legislative journals, as well as oral testimony that alleged that certain proposed amendments that were rejected in the assembly were nonetheless and apparently mistakenly incorporated into a final statute by the enrolling clerk of the state Senate. Now, with that background on the EBR, I want to make the following proposal for consideration by the California judiciary. So the California Constitution in Article 4, Section 1, of course, vests the legislative power of the state in the legislature and reserves the power of initiative and referendum with the people. Now, this inherent and plenary lawmaking power includes the authority to adopt any necessary procedural requirements for enacting statutes. That's set forth in Article 4, Section 7A. And as a result of Section 7A, the legislature at each biennial session's beginning adopts the joint rules of the Assembly and Senate, as well as the Senate rules and the Assembly rules by the respective houses. Now, while California courts have historically applied the EBR to bar the use of extrinsic evidence to determine whether the legislature failed to satisfy the constitutional requirements for enacting a statute, going forward, my proposal would be that there should be a distinction between constitutional and statutory-based challenges to an enacted bill, and those based on the legislature's internal rules. Now, this distinction can be easily drawn by the judiciary in any future decisions. In other words, under this proposal, legal challenges that are based upon an alleged violation of the state constitution or the California Government Code would be subject to judicial review. However, under my proposed approach, compliance with the internal rules of the legislature, i.e. the joint rules, assembly rules, and Senate rules, would not be subject to judicial review, i.e. they would be protected by the EBR. Now, this proposal is rooted in Article 4, Section 7A, again, which provides the legislature with authority to elect its officers and adopt its own rules for its internal proceedings. And as I mentioned, they do this every 2-year session by adopting the joint rules applicable to both houses, as well as the respective House rules, the Assembly rules and the Senate rules. They even have committee rules. So most, if not all, of the 33 Assembly standing committees and the 22 Senate standing committees have their own individual committee rules. So alleged violations of these internal rules should be subject to the enrolled bill rule. In that regard, a court would be precluded from basically entertaining any legal challenge against an enacted statute based upon an alleged violation of the legislature's own internal rules. So as an example, if a legal challenge to an enacted bill were based upon one house or even both houses not complying with the 4-day file notice, meaning a committee's notice of a hearing on a bill, they failed to comply with the 4-day file notice, which is provided in the joint rules of the legislature, then that sort of a legal challenge would be subject to the EBR and would be rejected by the courts. Again, this is due to the fact that judiciary would in fact be violating the separation of powers doctrine because the legislature has explicit constitutional authority in Article 4, Section 7A to adopt its internal rules. However, the enrolled bill rule should not be used any future proceedings that would prevent a challenge to a statute that a constitutional provision or a state statute found in the government code had allegedly been violated when the legislature enacted a bill. An example, the 72-hour in print rule that was adopted by the voters in Prop 54. It amended Article 4, Section 8B2. Now, if the allegation was that the 72-hour in print rule had been violated, then the state's courts, in fact, should entertain such a legal challenge because it would be based upon a potential violation of the California Constitution, not the legislature's internal rules. Again, this distinction between the procedural rules that are embodied in our state constitution, as well as statutes found in the California Government Code, should be distinguished by those internal rules of the legislature. And this is an easy, discernible, clear line that can be determined by both litigants as well as the judicial branch of state government. And by adopting this approach to the enrolled bill rule, then there would be a check by the judicial branch that the legislature has in fact complied with any constitutionally based or statutory based requirement for enacting a new law here in the state of California.